Mr. President, as your honours, as my colleague for legal representative of victims 1 indicated, I intend to focus on the question CA, the first question under C, namely, when the prosecutor requests authorisation to initiate an investigation having considered Article 53(1)(c) of the statute, does the pre-trial chamber have the power to consider the factors under Article 53(1)(c) of the statute itself? It's submitted that the pre-trial chamber erred when denying the request for the prosecutor by concluding at paragraph 35 that the scrutiny mandated to the pre-trial chamber in the proceedings under Article 15 is not limited in determining whether there is a reasonable basis to believe that crimes under the court's jurisdiction have been committed, but must include a positive determination to the effect that investigations would be in the interests of justice. And it is submitted that the statute does not empower a pre-trial chamber to decide that an investigation is contrary to the interests of justice when the prosecutor has not made that assessment. Instead, a pre-trial chamber is only ever at most empowered to review a prosecutor's decision not to initiate an investigation because it would not be in the interests of justice. As a basic starting point, we say that that is clear from the plain words of the statute when one looks at Article 53(3)(a), dealing with the request by a state under Article 14 or the Security Council under Article 13. It reads that the pre-trial chamber may review a decision of the prosecutor under paragraph 1 or 2 not to proceed and may request the prosecutor to reconsider that decision. There's a slightly different mechanism within 3B, where it reads that in addition, the pre-trial chamber may on its own initiative review a decision of the prosecutor not to proceed if it is based solely on paragraph 1C or 2C. And it differs in saying that in such a case, the decision of the prosecutor shall be effective only if confirmed by the pre-trial chamber. So we say that the statute is unambiguous and explicit in only providing the power to the pre-trial chamber to review a decision of the prosecutor not to proceed. And to expand on that submission very briefly, the statute does not accord to the pre-trial chamber the power to review a decision of the prosecutor to proceed or not to proceed. It's only not to proceed. And moreover, there is no room, we respectfully submit, for the statute to be reasonably read as being silent as to whether the pre-trial chamber has the power to review a decision of the prosecutor to proceed. And that much goes both in relation to 53(3)(a), the referral, and 53(3)(b), the proprio mutuum. Moreover, whilst it is recognised that the appeals chamber has not decided question CA before, we say that the consistent view taken by other pre-trial chambers on Article 15 decisions, where there is reasoning as to the basis for taking the decision, is to conclude that the court may only review the prosecution decision on interests of justice where the prosecutors decline to prosecute on that basis. And we submit that the reasoning supporting such a conclusion in those previous Article 15 decisions of the pre-trial chamber is compelling and unassailable. We say with the greatest respect to Ms Brady that we need to significantly qualify the assertion that all previous decisions of the pre-trial chambers in relation to Article 15 looked at all the 53(1)(a) to C considerations. So far as the Kenya decision was concerned in 2010, we note that the Kenya reasoning was rigorous and thoroughgoing. It analysed the history of Articles 15 and 53 and the interrelationship between Articles 15 and 53. It recognised the importance of the Vienna Convention, and it recognised the review standard that the pre-trial chamber was required to apply in relation to Article 15 decisions, but said at footnotes 35 and paragraph 63, as for the assessment of interests of justice under Article 53(1)(c), the chamber considers that its review is only triggered when the prosecutor decides not to proceed on the basis of this clause. Indeed, unlike the assessment to be made in accordance with Article 53(1)(a) and (b), the prosecutor is not required to positively determine that an investigation is in the interests of justice, and then crucially we say, does not have to present reasons or supporting material in this respect. It's only when the prosecutor decides that an investigation would not be in the interest of justice that he or she must notify the chamber of the reasons for such a decision not to proceed, therefore triggering the review power of the chamber. The Côte d'Ivoire case in 2011, we say, builds on the analysis in the Kenyan case and in effect repeats the findings of the Kenyan pretrial chamber. At paragraph 207, it reads, unlike subparagraphs A and B of Article 53(1) of the statute, which require an affirmative finding, subparagraph C does not require the prosecutor to establish that an investigation is actually in the interest of justice. Indeed, the prosecutor does not have to present reasons or supporting material in this respect. It's only when the prosecutor decides that an investigation would not be in the interest of justice that he or she is under an obligation to notify the chamber of the reasons for the decision. And again, to enable the chamber to exercise its power.
Excuse me, Counsel, a little bit slower, please.
I am sorry, Mr. President. It's because I was reading
the translation
from the authority.
Thank you very much.
To enable the chamber to exercise its power of review in accordance with Article 53(3)(b) of the statute. And we say that the importance of that passage is that it elaborates that the prosecution does not have to provide material or reasons to justify the investigation as being in the interest of justice, and therefore the pretrial chamber does not conduct a review unless it is a review of the decision to not proceed. And that would follow because there are no reasons to review, and there is no material upon which the review can be based unless there is a decision to not proceed because of Article 53(1)(c). We also draw some support from the Darfur situation, document 185. We see that the principle was established in a different context before, and this precedes both the Kenya and Côte d'Ivoire decisions in the Darfur case, because that case was primarily concerned with the issue of whether an arrest warrant should be issued. The pretrial chamber observed at paragraph 18 that the prosecutor had been given by the state's parties the discretion to decide whether or not to request the initiation of a case, and one of the factors it must consider is whether or not it would be detrimental to the interest of justice to do so. At paragraph 19, the court then assessed the extent to which the state's parties have provided the chamber with the power to review the prosecution's exercise of its discretion. And at paragraphs 20 and 21, the pretrial chamber said, the chamber observes that Article 53(3)(b) of the statute expressly provides for the chamber's proprio motu review of any prosecutor's decision not to proceed, which is based solely on the interests of justice. And it goes on at paragraph 21, no matter whether the chamber's review power under this provision is only applicable in relation to the prosecution's decision to put an end to the investigation of a given situation, or whether it is also applicable in relation to each prosecution's decision not to prosecute a specific individual, the chamber emphasises that Article 53(3)(b) of the statute only confers upon the chamber the power to review the prosecution's exercise of its discretion when it results in a decision not to proceed. And that approach reflects practicalities, we say, of the operation of the statute, because there is no mechanism for the prosecution to be required to give reasons as to why an investigation is in the interests of justice. All that exists is that duty in a negative position. And therefore, the mechanism for the review of the decision, that, taking into account the gravity of the crime and the interests of the victims, there are none less substantial reasons to believe that an investigation would not serve the interests of justice, is only created by virtue of the prosecution making the negative decision and informing the pretrial chamber of it. So it's framed in that negative way in the statute, and on a practical level in this case, there was nothing on which a review might be based, because the pretrial chamber in this case did not require any interests of justice justification from the prosecutor for initiating the investigation. And consequently, we say that the pretrial chamber in this case did not carry out a review. There was nothing to review. We say that the pretrial chamber simply made a de novo decision about the interests of justice. And one final point in just this section, and then I've just come to conclude on the review function. on the importance of the negative assessment of interests of justice, it's demonstrated really by what we say is the final sentence of Article 53.3, which reads, in such a case, the decision of the prosecutor shall be effective only if confirmed by the pre-trial chamber. The process is one of confirming a decision not to commence an investigation. The whole of this part of the article speaks of the decision of the prosecution to not proceed on the basis of 1C or 2C, and links the last sentence by saying, in effect and in reality, in addition, the pre-trial chamber may, on its own initiative, review a decision of the prosecutor not to proceed if it is based solely on paragraph 1C or 2C. In such a case, the decision of the prosecutor shall be effective only if confirmed by the trial chamber. Thus, the decision to not proceed is only effective if confirmed by the pre-trial chamber. It does not stipulate that the decision to proceed shall only be effective if confirmed by the pre-trial chamber. And finally, just to return to the question of what review means, there must be a review of the decision. It isn't simply a de novo decision-making process. And if I may say with respect, paragraph 16 of the opinion of Her Honour Judge Fernandez in the Côte d'Ivoire case, and indeed paragraph 18, makes that point. Mr. Dixon referred to reviewing by domestic states, of the standard of review of the prosecutorial discretion in some domestic states is very strict, and rightly so. And just to take the example of England and Wales, the threshold for judicial review of a prosecution decision, even to not prosecute, is extremely high, and the courts do not take the view that the consideration of the interests of justice is for them, let alone that it can only ever be for the courts. There has never been a successful judicial review of a Crown Prosecution Service decision to prosecute in England and Wales. And indeed, the Crown Prosecution Service guidance on judicial review of prosecutorial discretion in England and Wales says the following: the authorities are now clear. In the absence of exceptional circumstances, the decision to prosecute will not be amenable to judicial review in the High Court, as the arguments can be dealt with within the criminal trial in the Magistrates' Court or Crown Court. Such exceptional circumstances might be dishonesty or malafides on the part of the prosecutor, but one might argue that the law on abuse of process is sufficiently developed to deal even with those circumstances. So we therefore submit in conclusion that by assuming a power to assess the interests of justice in circumstances other than to review the prosecutor's discretionary decision not to investigate, the pre-trial chamber has acted ultra vires in this case.